Welcome, everyone. I'm Jim Glassman. I'm a visiting fellow at the American Enterprise Institute, and I'm just back from Silicon Valley, and by just, I mean like 7 hours ago. And if you want to be invigorated about what's happening in America, go to a place like Silicon Valley or Austin or the suburbs of Washington, D.C. But Washington is absolutely vital to the innovation that's going on across the country. And for innovation to work, we've got to get the platform right, or as my former colleague Nick Schultz refers to it, the intangible assets right. That is to say, the rule of law and what laws, the tax system, the immigration system. And that's why in September of last year, the American Enterprise Institute launched the Center for Internet Communications and the Center for, Caro's going to get me on this. The Center for Internet Communications and Technology Policy, or CICT. Our leader is Jeff Eisenach, who's not here today, but has Jeff. Oh, there he is. Good. Our leader, who's done a fabulous job of bringing together, at this point, about a dozen fellows from across the country. In fact, I was with one of them in San Francisco just a couple days ago. And these are experts on both technology and policy in 5 areas. Telecommunications regulatory policy, which is very important right now. Cybersecurity, actually all these things are very important right now. Privacy, antitrust, and what we're going to talk about today, which is intellectual property. Specifically discussing patent assertion entities, sometimes called trolls. This is one of those very complicated issues, unlike a lot of things we deal with at the American Enterprise Institute, like free trade, low taxes. Those are kind of easy. We know what the answers are, at least some of us think we know what the answers are. Intellectual property is difficult, and the details are very, very important. And that's why we're very fortunate today to have Noah Phillips. Senator Cornyn, as you know, unavoidably could not come, and we're disappointed in that, but we're very happy to have Noah Phillips here, who's the Senator's chief counsel and really knows this subject very, very well. He's a graduate of Dartmouth and the Stanford Law School. He was a clerk to Judge Prado on the Fifth Circuit Court of Appeals, and then went into private practice at Cravath in New York and Steptoe and Johnson here in Washington, D.C. He will speak to us, and then we will have a spirited panel discussion after that, which Michael Rosen will moderate. I do want to say that because of matters of time, Noah is not going to be able to answer any questions, but he will explain the Senator's legislation and the state of the art of the law right now. Noah.
Thanks so much, Jim. To all of you, Senator Cornyn sends his regrets. He had to be in Texas today. And I offer my apologies for what must be a tremendous disappointment for those of you who are hoping to come here from the second-ranking Republican in the U.S. Senate and the senior senator from Texas and instead get me. So my apologies for that. Senator Cornyn, whose remarks I'm going to deliver today, wanted to thank everyone at AEI for organizing today's panel, and everyone here for coming, some of you from very long distances, to such an early event, especially since patent reform is supposed to be one of those boring issues that only a handful of people understand or care about. But in all seriousness, as all of us know, many of these so-called boring issues are actually quite important to the U.S. economy and its long-term growth potential. So, while introducing a patent reform bill may not be the best way to get oneself a primetime appearance on Fox News, Senator Cornyn is encouraged that the ideas in his bill have attracted strong bipartisan support. We always hear that Washington, D.C. is simply paralyzed by ideological stalemate and partisan gridlock, with Republicans and Democrats unable to find any common ground whatsoever. Senator Cornyn would tell you that patent reform is an issue where, despite everything, members of both parties have found common ground. Even more encouraging, there's a very real chance that we could push a major reform bill across the finish line before Election Day. What Republicans and Democrats alike have come to realize is that under America's current legal regime, too many of our most promising innovators, not to mention other businesses, are wasting their time and money in frivolous, costly litigation brought by so-called patent trolls. A more efficient patent system would reduce uncertainty among inventors, increase private R&D expenditure, and unleash new innovation and boost job growth. Abusive patent litigation is hardly a new phenomenon. In fact, it dates back at least as far as the early 1800s. In those days, people didn't call them patent trolls. They actually called them patent sharks. The sharks emerged after the US Patent Office eased the standards for patenting farm tools. After acquiring poor quality patents on basic tools like shovels and plows, the sharks would use the patents as leverage to extort payment from farmers. Fortunately, the Patent Office eventually went back to a stricter standard, and the problem essentially went away, but only temporarily. In recent years, the proliferation of smartphones, high-speed internet, and the related software and hardware has been accompanied by a boom in abusive patent litigation. What was once merely a nuisance has become a significant burden on the US economy in general and the US innovation sector in particular. Just how big of a burden? Well, let's look at some of the numbers. In 2008, US courts heard about 2,400 patent infringement cases. Of those, about 1 in 4 were brought by so-called non-practicing entities, or NPEs, which is just the dinner table appropriate term for patent trolls. 4 years later, in 2012, the courts heard more than 4,700 patent infringement cases. Of those, a whopping 65% were brought by NPEs. To give you a sense of how expensive this litigation can be, a recent study by 2 Boston University law school professors calculated that in 2011, the direct crude costs of NPE patent assertions added up to $29 billion. That's $29 billion in a single year. And remember, those were just the direct costs. The indirect costs include the enormous amount of time that company personnel spend away from their jobs responding to the lawsuits, along with the related disruptions in their innovation work. The total costs, that is the direct and indirect costs combined, have been estimated at $80 billion a year. These are estimates, of course, but whatever the precise number, it is very, very large. And even that figure, the $80 billion figure, doesn't account for all the private firms and small startups operating out of basements and garages, nor does it account for all of the budding entrepreneurs who are discouraged from pursuing innovation activities by fear of lawsuits. Back to the direct costs for a minute. The BU study showed that 37% of those costs were shouldered by small and medium-sized firms. It also made a larger point about how patent trolls affect these firms' ability to innovate. I quote, "Publicly traded NPEs cost small and medium-sized firms more money than these NPEs could possibly transfer to inventors. This reduces the net amount that firms of any size have available to invest in innovation. In economics, these costs are referred to as deadweight loss, and they represent a glaring inefficiency. Just to be clear, there is nothing wrong with free trade in patents, but the rise of patent trolling has fostered a legal environment in which genuine IP rights are being undermined. The bill Senator Cornyn introduced last year, the Patent Abuse Reduction Act, would make several key reforms aimed at discouraging abusive litigation. Number one, it would require all plaintiffs in patent cases to reveal their identity and explain the substance of their claim when filing the initial lawsuit. Number two, It would allow all defendants in these cases to have interested parties hailed into court for the purpose of paying fees. Number 3, it would bring greater fairness to the discovery process by reducing cost asymmetries. And finally, it would shift responsibility for the cost of patent litigation to the losing party unless the losing party's case was a reasonable one. Senator Cornyn strongly believes, and many of his colleagues agree, that these reforms would help deter patent trolls and would significantly reduce the annual costs of patent litigation without unduly compromising the rights of legitimate intellectual property holders. Many private companies and organizations seem to agree. Senator Cornyn is proud to report that the Patent Abuse Reduction Act has been endorsed by, among others, the Application Developers Alliance, the Software and Information Industry Association, the Coalition for Patent Fairness, the Austin Technology Council, Engine Advocacy, the I2 Coalition, the Texas Association of Business, and the Business Software Alliance. Just a few final thoughts on the importance of innovation to America's economic future. A 2010 Commerce Department study estimated that factors linked to technological innovation, such as capital investment and increased efficiency, have accounted for nearly 3/4 of America's average annual growth rate since World War II. 3/4. Everyone in this room knows that the global economy has never been more competitive than it is today, and that capital has never been more mobile. America still boasts a world-class innovation climate, and we're certainly still a global innovation leader. But at the same time, we cannot afford to get complacent. In the 2013 Global Innovation Index, published by researchers at Cornell, INSEAD, and the World Intellectual Property Organization, America ranked 5th, behind the Netherlands, the United Kingdom, Sweden, and Switzerland. As we move forward, Senator Cornyn hopes that his Patent Abuse Reduction Act is just one element of a broader, comprehensive innovation agenda designed to update our tax, legal, and regulatory policies for the 21st century. Thank you all for having me today. The Senator, again, sends his regrets, and thanks for your interest in the boring old issue of patent reform.
Thank you, Noah. It's got to go back to markup. A lot of exciting things going on right now in the patent world, a lot of ferment, and we have a terrific panel, and I'm just going to introduce Michael Rosen, who will then introduce the panel. Michael Rosen is one of the 13 fellows who are part of the Center for Internet Communications and Technology Policy Center at AEI. Michael is a practicing intellectual property attorney in San Diego. He's also an adjunct professor at the University of San Diego Law School. He's a frequent contributor to, among other publications, the American Politico Weekly Standard. So, Michael, if you will come up and take it away.
Thank you, Jim, and thank you very much to all of you for attending, and thank you to the Institute and the Center in particular for arranging this event on this topic. I don't know what Jim is talking about. I don't find this topic boring at all. It's scintillating. For anyone in the IP world, patent troll reform, so to speak, is quite a fascinating topic, and I think from the panel that we're about to introduce, you'll see there's an incredible breadth and depth of knowledge on these issues and a range of opinions that really span the spectrum and make for really quite a fascinating public policy debate. It's a privilege to be here to be moderating this event here in the Senate in the Russell Building. I think it was George Washington who described the Senate as the saucer into which we pour legislation to cool. Now, first of all, I think the metaphor is a little strained because I don't think you pour liquid into a saucer. You pour it into a teacup, which rests in a saucer. But it's sort of an indirect way of saying that the Senate, the impolite way of saying it is the Senate is where bills go to die. But more politely, I suppose, the Senate is the place where the heat and passion of legislative debates can take a more deliberative format. And I think that's what we hope to do today, to really get into these issues in depth, to analyze them from all different angles, and to look at them from perspectives that maybe some of us wouldn't have thought of to begin with. Now, this debate, I think in particular, the role of the Senate is interesting here, because 10 years ago, in a way, we've seen this movie before. Around 10 years ago, there was another big push for patent reform, and ultimately that culminated 3 years ago in what's now called the America Invents Act, the AIA. And a lot of the similar trends that we're seeing now, I think, happened back then. You had a big push, largely from the computer software and hardware industry, largely based in Silicon Valley, to try to rein in the excesses of the patent system, to try to weed out bad patents, to make sure that litigation was run efficiently, et cetera. And there was a lot of momentum for some very significant changes to the patent system. And then that encountered a bit of a backlash from other sort of players in the economy and the technology world, primarily from pharma and biotech sectors, but from others as well. And eventually what wound up happening was a compromise bill, the AIA, which is, I think, a significant piece of legislation, the most significant piece of legislation to pass Congress on patent reform in centuries, yet still only a fraction of what was initially talked about in terms of changes to the system. There's been a similar development here, I believe, in the last few years over so-called patent troll reform. And as we'll see as we get into the topic, there's been this similar trend of a very large push and then a little bit of a push back. And now it appears this week they're actually going to mark up or perhaps working on a manager's amendment of some of these aspects. And it'll be interesting to hear from some of you in this room what your perspective is on how that will turn about. So I'm going to introduce the speakers. What I would really like this panel to be in this more of a round table, although it's two rectangular tables, but imagine that they're round. We want this to be very interactive, and we'll go through a number of different questions and have the panelists all jump in. But please, we invite you to raise questions, to offer your insights and comments as we go through too. Don't be bashful. I'm not going to save questions for the end. Please jump in really as we go. So with that said, let me introduce our speakers. And these are in alphabetical order. So number one, John Ellenthal is the Chief CEO and Vice Chairman of Patent Properties, an intellectual property company that develops and commercializes patents and other IP assets created by the R&D lab Walker Digital. He's also the president of TEDMed LLC and a partner in the company. For the past 5 years, Ellenthal served as the CEO of Walker Digital and was responsible for all business operations, R&D, and IP, Internet Protocol portfolio licensing. Julie Hopkins is a partner at Tidings and Rosenberg in Baltimore and is the chair of the firm's intellectual property group. She's a registered patent attorney who represents domestic and international clients in patent counseling and procurement. She helps clients patent, protect, and commercialize inventions in numerous technology areas. She also practices trademark prosecution, registration, and enforcement with an emphasis on searching and clearing brand names, logos, slogans, and trade dress. Her litigation experience includes various forms of IP actions in U.S. district courts, and she's also represented clients in appeals before the Third Circuit Court of Appeals and the Federal Circuit, and has published numerous articles in publications like the Hills Congress blog, IP Watchdog, UPI, the Denver Post, the Austin American Statesman, and Recode. Welcome to Julie as well. Gail Levine is Vice President and Associate General Counsel for Intellectual Property and Federal Regulatory Affairs at Verizon. She is responsible for shaping the company's patent policy program, leading its Federal Trade Commission initiatives, and coordinating its advocacy on the so-called Internet of Things. Until 2011, she handled antitrust and patent issues as Assistant General Counsel at Verizon. She also serves on the Council of the Antitrust section of the ABA, and also chaired the IP Working Group of the ABA Antitrust Section's 2012 Transition Task Force, which offered recommendations to the Obama administration on antitrust and consumer protection issues. Welcome, Gail. Todd Moore is an app developer, technology host, and published author. He created the popular smartphone app White Noise, which has been recommended by numerous celebrities, including Dr. Oz, Savannah Guthrie, and Maria Menounos. I think I'm pronouncing that right, and has been downloaded by millions of customers. His book, Tap, Move, and Shake, which featured a foreword by Steve Wozniak of Apple, shows how anyone can publish their ideas to the iTunes App Store. Welcome, Todd, as well. Lori Self is Vice President and Counsel of Government Affairs at Qualcomm, Inc., where she specializes in intellectual property law and related policy matters. She represents Qualcomm before Congress and a number of U.S. government offices. She also supports Qualcomm's strategy and initiatives to promote strong IP rights in China and other emerging markets, and to combat counterfeiting and gray market mobile devices and components. Her focus is to ensure that U.S. IP and trade policies provide the necessary protections and incentives to support Qualcomm's R&D-driven business model. Before arriving at Qualcomm, Lori was a partner at the law firm of Covington & Burling, where she chaired the firm's IP practice group. And last but not least, Lawrence Waugh is a former U.S. Navy carrier pilot and a co-founder of Calavista Software, a software development firm that uses its licensed, proprietary, and patented development tools and testing services to help other companies improve the quality of software delivery. Before founding Calavista, he was recruited by Trilogy Software in Austin and spent 7 years working with various enterprise software companies in developing and consulting roles ranging from individual contributors to vice president of engineering. During that time, he became passionately concerned with software quality and the development processes and tools that promote it. So, those are our speakers. We'd like to give them a round of applause as they come up and take their seats at the rectangular round table.
Hi, John. Nice to see you. All right.
So welcome again, and what we're going to start off with, the first question that I would like the panel to address is, at a general level, what would you say the 3 largest, most important problems facing the U.S. technology market are when it comes to issues of so-called patent trolls? We'll put scare quotes around that for now and see how that goes. And what I'm really trying to get at here is what obviously drives the debate on the solutions are the problems. So I think it's important to first try to identify the problems, and let's see if we can start with that. So I think I'm going to turn to Gail to give us our first thoughts on what are the top 3 problems posed by patent trolls, and then we'll turn to the rest of the panel.
I'm going to start by cheating and giving you one problem, but it's big enough to count for 3, right? So one of the major problems that Noah was able to highlight in his opening remarks is one that we are also very concerned about. Some entities are using patents to tax innovation, not to promote it. And they're doing that sometimes by accusing innovators of infringement, not to capture the value of the patents, but to demand some fraction of the transaction costs, some fraction of what you'd have to spend to disprove infringement. That's what you'd have to spend to fight them in court, essentially. That's a big problem for companies like ours. That's a perhaps even bigger problem for companies, for smaller companies who don't have the budgets to fight off entities bringing patents as a weapon, patents as an opportunity to tax, not promote innovation. They, in some situations, and others on the panel perhaps can speak to this, but they sometimes find themselves in a position where they have to pay up just to avoid the transaction costs of going to. And they find themselves with really no other option than paying. That's why I'm so pleased that Noah was able to outline the excellent aspects of Senator Cornyn's bill. Senator Cornyn's bill by and large, aims to solve the problem of these nuisance patent actions, aims to make patent litigation more efficient. If patent litigation is more efficient, the incentive to bring patent cases less for their merits than for their costs goes down. That's why we support those provisions.
Of course.
So the question was, why would any patent troll sue Verizon in court because it's going to lose? Well, I couldn't agree with you more. I only wish more patents right? We are, you may be surprised to learn about at the number of meritless patent lawsuits brought against Verizon, but we're not unique that way. You know, I could have been replaced on this panel with any number of high-tech companies who face the same problems. I think the problem probably stems from the fact that a lot of high-tech products are viewed as having thousands, more than thousands, of patents per product. In other industries, that may be less true. In other industries, sometimes, I'm no pharma expert, but I am told that in pharma, roughly speaking, I simplify to make the point, but roughly speaking, it's one patent per product. Right? When you've got thousands of patents per product, the opportunity for any one of those thousands of rights to be brought against the product, either to take it down or to extract too much in the way of its value, is just overwhelming.
Other panelists care to comment on the problem as you see it, such as it is?
Well, I think that it's just such an asymmetrical problem in that small businesses, and you know, I own a small business, TM Soft, and we have like 3 employees. There's just no way you can fight these guys. They'll bring a frivolous lawsuit against you, and it'll cost upwards of millions of dollars to defend yourself. And I mean, to me, that's the biggest problem. Their business model, the patent trolling business model, is very cheap to operate. It doesn't cost much money to drag people into these lawsuits and then tell them, as in my case, pay us some money and we'll dismiss it. And that's what we need to solve here. We need to make that business model more expensive for them.
Or cheaper on both sides.
Yeah, can I offer?
Of course, please, Lori.
Sure. So let me just say at the outset that Qualcomm has obviously a very large patent portfolio. We have one of the largest and most valuable patent portfolios in the mobile space. We license our patents broadly, so we care deeply about the protection of patent rights. But at the same time, every patent suit that we're involved in today, which is about 20 per year, we are a defendant in. So we understand the dynamic of, you know, the so-called troll using the shell company business model backed by, you know, potentially a private equity fund, a hedge fund, what have you, to pursue big companies. But I also think it's important to step back and try to understand the sort of the empirical data, the context. You know, Noah cited some statistics that are widely touted, the $29 billion number, the $80 billion number. Some of those studies equate trolls with any business, any entity that does not manufacture a product. So it could be universities, research firms, independent inventors, garage inventors, you know, even Qualcomm, if you sort of put aside our chip business. And I think that's a real problem because we don't, in trying to address the kind of dynamic that Gail and Todd are describing that we face, we don't want to tilt the playing field so far against the rights of patent owners that we're really hurting legitimate patent owners and legitimate patent rights. So I just think it's important to, as we talk about the troll abuse problem and as we recognize that abuse exists in this system as in any other, you know, let's target that abuse without creating collateral damage of the enormously valuable innovators that make up our patent system.
Yeah, picking up on Lori's comments, you know, we believe the biggest problem is the sheer expense of patent litigation, and it is an asymmetrical problem in that many companies cannot afford to defend themselves, even when the merits are on their side. But it's also true that many legitimate patent owners cannot afford to avail themselves of the court system because of the very high costs. So we have and filing a lawsuit is pretty much the primary way that a patent owner goes about trying to unlock the commercial value of its asset and diffuse its innovation into the marketplace. So the biggest problem from our view is that we have a litigation or bust model at the moment. So it's a little bit like if the only way to fly in this country was private jet travel, guess what? Far fewer of us would fly. And there would be much less economic activity because fewer of us were circulating through the economy. When litigation, when you need the credible threat of litigation to have a fair, good faith license negotiation, then we have a jet travel only system. So we need a system we need a system that basically allows all patent owners and all American businesses to do business in a completely voluntary and commercially sensible way. A litigation-only path is bad, not just for the very small companies like the gentleman at the end, but it's also very bad for all the small companies that are inventors. So we need to figure out how to ultimately, the $29 billion that Boston University talks about is out there all the time. Forrester Research did a study that determined that American firms annually cost themselves waste $1 trillion for underutilizing IP assets. So the big problem, the root problem, is our systemic inability to get patented inventions into the economy where American businesses can use them to improve their products, lower their costs, and compete in a hard-fought global economy.
Thank you, John, and I'll actually ask Lawrence to comment on this, but one other point I would make about the problems that we're facing hasn't been mentioned yet. In addition to litigation, which is a major significant driver of the issues that we're seeing in the system, another big cause and motivation for the legislative push has been this spate of so-called patent assertion demand letters that a number of patent assertion entities have been sending out. Litigation is the primary means by which these patent assertion entities obtain or figure out a way to commercialize their IP. But another significant way is simply sending out these batch form letters to thousands and thousands of recipients seeking a settlement of $10,000, $15,000, $20,000 to try to close out these issues and try to unlock the value of those patents. And we'll talk about some of those efforts at the state level to rein in this practice a little bit later. But Lawrence, maybe you can provide a little of your own personal insight into this issue.
Yes, I'd be happy to. So as a very practical example, we can talk in general about patent trolls and the effect on the economy and things, but as a sort of direct example, I run a small company. I've received, not so long ago, last year sometime, a demand letter from a company I'd never heard of. It was an LLC that was put together to basically enforce a patent. It claimed that it was likely that I was infringing their patent, basically if I had a fax machine that had certain or a scanner that had certain capabilities. Said I had such a scanner. It was from Hewlett-Packard. They made the point that, question, why are we not suing Hewlett-Packard? Well, because Hewlett-Packard is not actually infringing our patent by building the machine. It is you who is infringing the patent by using the machine. And to your point, it's very clear why they're not suing Hewlett-Packard. But we've decided that the fair use value of this functionality that you get by pressing this button on your machine is about $1,000 per employee. So if you'll write us a check for that, then we'll just go away. Otherwise, we won't. We'll take you to court. And since you've now received this letter, you are subject to treble damages because you are now willfully infringing our patent. And so now we're talking about a check that could be into the six figures for a very small company. This is a real thing for us, to have to stop as the owner of a company or the CEO of a company and stop and decide, what are we going to do with this? Are we actually going to write a check for 5 figures and be done with this and just sigh and move on? Or are we going to fight them in court for easily into 6 figures in lawyers' fees? I mean, lawyers, $300, $400 an hour. Or do we just ignore it and hope they go away and now be liable for triple damages? So it's a real thing that, that is going on, and I see it as a real problem. Summing the problems up, one is I don't know that I'm infringing a patent until I get some letter that says, by the way, you've done this. Clearly, I'm not the one who's really doing the infringing. But beyond that, as someone has said, the troll has no financial incentive to not do this. They sent out, and did some research, they sent out 17,000 of these letters. So if you do the math and you think, okay, the average recipient of this letter has maybe 25 employees, that's $25,000 times 17,000, you can work that out. It's something on the order of $5 million. I'd have to do the math. It's a very large number, and you realize that you don't have to get a very high return, percentage-wise, to make that financially worthwhile for you as a troll. That's just got to stop.
Thank you, Lawrence. Yes, sir.
So that would be an approach. This has actually been circumvented. So I didn't know that they didn't announce in this letter that 17,000 companies are being, and here's who they are, that we're suing. This again, I got this letter last year. This has come up as I've done some research. It's kind of been, it's overcome by events because the Fair Trade Commission has actually gone after this particular troll. And so in this case, I'm not, I did not pay the check, and I am hopeful that I will not have to pay a check. But the point is, it's not always clear who is involved in this suit. If the letter came with a list of here's everyone that we're suing, or there was some easy way to figure that out, then I think that would be a good approach.
Once you get to the litigation phase, then that type of approach, I think, is a lot more plausible. But at this phase, when there's just no knowledge into who else is receiving these letters, that can be a challenge.
And to say beyond this, my business has nothing to do with patent litigation. My business is writing software for other companies. If I stop every time I get such a letter and try and figure out what's going on and put together a coalition of people and get it, well, that becomes my full-time job. And I don't know who's running my company, but it's not me at that point. And so, yes, while I agree that there would be defenses that could be mounted that would be effective, that is not what I want to spend my time doing.
Just to follow, though, on the gentleman's comment, I think it does raise an important issue, which is, when we talk about these demand letter scenarios, which I think, especially the mass mail type scenario that is being described, which I think everybody would agree is egregious and, deceptive and awful. I think one of the key goals is to shed daylight, though, on the practices that are taking place. And so PTO, for example, as one of their executive initiatives in response to the White House recommendations on improvements to the patent system, is going to be working with small businesses who receive these types of letters to create some sort of, I don't know whether it will be a database, but to create tools that will allow access to information about others who may be receiving these letters. I know other private organizations have done similar initiatives, but I do think shedding daylight on the initiative is a really important step because, our view is that once it becomes clear that this is really a pattern, a widespread pattern of abuse that's targeting small businesses, consumers, then it does fall within the existing authority of the FTC, state AGs under consumer protection laws, and then you have a path forward that takes the onus off the small business recipient and really shifts it to the government or the appropriate entity to pursue some sort of remedy. So I do feel like with the demand letters, there are some really practical steps that could make a big difference.
We'll talk about some of those as we go, but before we close out the issue of what the problems are, any other thoughts from the audience or questions from the audience on this issue? Yes, sir.
The panel seems to be avoiding problem for small, honest inventors with good patents who are faced with enormous costs, litigate with big corporations like Verizon, like your insurmountable barrier and burden on innovation by honest, small inventors.
Yeah, I tried to. Let me see if I can do so more clearly,
Please, yes.
Michael. You know, when I talked about the fact that the cost of litigation is the problem, and it is an asymmetrical problem in that it's used against companies like this gentleman who doesn't have the resources to defend himself from a frivolous or legitimate claim, but certainly a frivolous one. The same is true for American inventors who have spent a great deal of money on R&D and have spent additional money on legal services to obtain title to their invention. They can't participate in the legal system either because it's simply too expensive. So on the one hand, you can't afford to defend yourself if you've been targeted. On the other hand, if you are a legitimate patent holder with a legitimate claim, you can't afford to participate in the system either because it's cost prohibitive. So we've spent $5 trillion in the last 20 years by American business and by the US government on R&D, basically to come up, design new ways to solve problems. And many of the results of that $5 million investment are in the form of the 2.1 or 2.4 million active patents that we have today, yet only a couple of percentage points of those patents have ever generated the first dollar of licensing revenue. 95+% of the patents that have been invested in by small companies have never generated a single dollar of licensing revenue, and they've never gone on to be used by a third party to improve a product or reduce a cost. So that is as big of a problem as any. Here are the numbers. 60% of patents are owned by universities, research labs, independent inventors, and small companies. They generate 1% of the licensing revenue in today's market. So we need a way for businesses to participate and get access to the innovation they need under commercially sensible conditions, and we need a way for American inventors to participate in the economy and get value back for their investment in R&D, for their teachings. So I agree with you, sir.
Just turned it off.
Doesn't address the sweeping nature of this particular legislation.
And we'll
It covers everybody.
right.
There might be, one person in this room that's, committed a crime. And this legislation would cover everybody in the room. That's, small inventor, that's not Verizon, that's not AT&T, not Microsoft or Goldman Sachs.
And we'll talk about, we're going to spend the bulk of our time talking precisely about the legislation, and I agree, I think in some ways it is a one-size-fits-all piece, so.
Can I just
when I-
add to that?
Yes, please, go ahead, Gil.
Just, to add to John's comments, a lot of the features of Senator Cornyn's bill that Noah was talking about this morning aim to make patent litigation more efficient across the board. So it is hoped that it will bring down the unduly high transaction costs of patent litigation on all fronts. Right? So that's just a word in favor of those provisions.
Just to-
But let me just add one other thing. And I thought John made an interesting point about the underused patents that exist in the economy. There are two different kinds of conversations patent holders may possibly have with you. One, if you're a company. One conversation is the patent holder says to you, I have a patent and you're not using it. This is my patent that, I think, and this is maybe what you're envisioning. I have a patent that will reduce your costs, that will make your product better, that will make your consumers love what you have to offer. You're not using it yet. Why don't you start using it? And of course, you'll owe me something because it was my idea. Yeah, I've got a patent on it. But you're not doing it yet. Do it and it will make your products better. It will make your consumers happier. Right? That's one conversation. Another conversation is the kind of conversation that leads to litigation. That second conversation is, I have a patent that will, on whatever, I have a patent, and you're already practicing it. You're already doing the thing that I have a patent on. This conversation is not about making your products better, making your consumers happier, because the product you're selling is already there doing it. Maybe you independently invented it, maybe, who knows why, but the product is already on the market. Nothing is going to be made better for consumers in this second conversation. Prices, money changes hands, right? Litigation happens. By definition, only the second conversation leads immediately to court. Infringement allegations are what happened in that second conversation. The first conversation is an invitation to innovate. The second conversation is more akin to a conversation about taxing existing innovation.
So if I could just comment, because when I mentioned collateral damage, I was trying to reference your concern about small inventors. I mean, I do think that in our rush to judgment, this kind of, oh my gosh, there's a troll crisis, let's do something today. Very often the legislation that's put forward, and we saw this on the House side, is crafted through the lens of the big corporate implementers, the ones who have defined the problem and who are driving the reform effort. And so I do think, as was mentioned earlier, on the Senate side, this is where we have the opportunity to recalibrate, to make sure that we get it right, to make sure that we're not affecting this sort of massive overcorrection that's going to harm thousands, if not millions, of small inventors in order to get the small percentage of bad actors that are out there. And I also, just to echo your point, from Qualcomm, I mean, we really look at these issues through the lens of the startup that we were in 1985. And we understand how hard it is to get an invention to market, and we understand the years of R&D that are invested before you know whether a patent is actually going to read on a viable product. So we understand how important maintaining a level, fair landscape is for small patent owners in particular. And so it is incredibly important that we get it right, that we strike the right balance, that we don't overcorrect, and that we look at these issues not only through the perspective of the recipients of demand letters, the targets of frivolous litigation, but also through the lens of small inventors who encounter abuse from big implementers. Yep, and it's a right, and we're working towards that. But I agree with your comment.
We'll talk about that in a moment. Our esteemed MC has a question for the panel as well.
I do have a little question while you're in the problem phase. And so there's been a lot of talk about asymmetry. But it seems to me that our entire legal system is fraught with asymmetry. So it costs a lot of money to file a lawsuit. It costs a lot of money to defend against the lawsuit. Whatever that lawsuit is.
I'd like to say it only costs $450 to file the lawsuit, and the cost of postage to send a demand letter. It's pretty cheap.
So file a lawsuit, but actually, so what makes this different? Why are we all concerned about IP and not about other aspects of the legal system that are, it seems to me, fairly simple?
I'll offer one thought on that, Jim, and also somewhat in response to the gentleman's question. One of the things that we've seen within the past 10 to 15 years could be considered a good thing, could be considered a bad thing, but from the perspective of small inventors, there now is a mechanism or a path for them to band together in order to try to equalize some of those asymmetries. There are a number of very well-funded and well-assembled patent aggregators out there, companies like Acacia or Intellectual Ventures, that manage to reach out to small inventors, to small companies, to small businesses, to solo inventors, and try to bring together some amount of market power, so to speak, that can put up a fight against the larger companies. So there still is, I think John's point is a very good one, that 60% of the patents out there are held by folks who are producing, was it 1% of revenue from their patents?
1% of the licensing share goes to those folks.
1% of that share. But that balance has shifted, at least somewhat in recent years, to the point that small inventors now are able to commercialize their inventions in a somewhat improved way.
Jim.
I don't think you're really addressing my question, as important as your comments are. I'm just trying to get at this issue of why this kind of struggle, legal struggle, more important to the economy. That's why we're addressing it.
I believe that it is. I believe that it is. This is an economic imperative. So, you know what, we've left the industrial age. We have a post-industrial economy. We live in the information economy. 80% of the value of Fortune 500 companies is made up of intangible assets. Not all intellectual property, but that's a meaningful part of it. So, you know what, in a global economy, everybody has access to the same raw materials. Everybody has access to the same production capabilities. Everybody has access to the same markets. What separates one product from another, what determines a winner or a loser in that environment, is our ability to apply intangibles to make our product more valuable or to make our product less expensively. So I think there's little question that from an economic standpoint, our country's intellectual property system, strategy, you know, directly affects our ability to create jobs for our companies to compete in a global economy.
Let me just get Julie to get in here.
I was going to say.
Yeah.
So.
Sorry, Julie. Sorry, Julie.
Understolen.
Sorry, Julie.
You'll get.
The problem of not having a round table is I didn't see you lean forward.
So as
You'll get him back later.
I'll add on to that. If the argument is that lawyers, with due apologies to my co-panelists, if that lawyers make too much money to do simple things, a small business owner, I'm right there with you. I would love to see the cost of I mean, I'm litigating a suit right now with the state of Texas. It's a ridiculous suit. It's going to cost me $100,000. The law says this. I just need to prove that the law says that to somebody, and there we have it, $100,000. I am absolutely agreed that the entire legal system is overburdened with fees. That's not the issue in front of me right now. The issue in front of me is patent law. That is something that there's a bill on, and I am not inclined to say, well, if we can't fix everything all at once, then let's not do anything. We have patent law reform in front of us, and so that's what I'd like to tackle.
Yeah, and Jim, adding on to the point that Julie made so well a minute ago, even though it was ventriloquism at its best, Julie is a very talented ventriloquist. You know what? The crazy part here is, look, we need to figure out how to optimize the legal system, whatever that ends up meaning. The crazy thing is that any industry that does all of its deals in the court system is not in good shape. And that's how the IP marketplace works today. So for us to really unlock the full economic value of this asset class, which I do believe is, and Julie believes, is very important to the economy, vital to the economy, we need to figure out how we're going to do deals in a simple and affordable way outside of the court system. If you look at divorce, you know what? It used to be to dissolve the marital contract, you had to go to court and prove to the judge you had the grounds to break the marriage. Very expensive, very long, very time-consuming, I assume very painful. I hope never to experience that. And then along came no-fault divorce, which created a viable alternative to the court system that was easier and less expensive to make a deal on how to end a marriage. We need to figure out how to do business outside the court system because the court system is inaccessible to almost everybody. I do notice that a lot of folks have gotten up to stand, which means, Michael, your chances of a standing ovation are much greater.
Oh, excellent. That's exactly what I was hoping for. Thanks, John. Well, and I think that's actually a good transition point to start talking about solutions. You know, the no-fault divorce is actually kind of a perfect example because many people would say that no-fault divorce itself as a solution to a serious problem led in turn to other unintended consequences. And we'll put family law and social policy aside for the moment. But just from that perspective, you can see that there's a really wide range of opinions, even on what the problems are. And you can see that just from our panel and from the comments in the room. So we may not even reach consensus on what the problems are, but we've certainly identified a number of them. And now let's turn to examining how the legislation, proposed legislation, is working to try to address those problems, or perhaps not working to try to address those problems. And what I'd like to start with is I'm going to turn to Todd to give us what he thinks are the top 3 priorities for what a successful patent legislative reform would need to look like. So let's start with you, Todd.
And I'd like to answer that question with telling you my personal story and how I got involved in coming onto these panels. And this is a very important issue. I'm a software developer. I write code every day. That's what I do. I like to build products. I like to build products that people need and use. And that's what I like to spend my time on. So I don't really want to be here. I want to be at the office building stuff that people need. 5 years ago, I created an app, a mobile app. It's called White Noise, and it plays relaxing sounds that help you sleep. I never thought that the sound of rain would infringe someone's patent. But I received a demand letter a few years ago that said I was infringing on one or more patents within a portfolio. I looked over that letter and I said, well, clearly a mistake must have been made. How could my little White Noise app be infringing on one or more patents? And it gets to that demand letter, and what we're talking about solutions, demand letter transparency. Who are these guys? And you look into it, and it's some shell company that has one person who's running the show, and you're like, well, they must be funded from somewhere, and you try to follow the chain, but it's all smoke and mirrors, and there's all these companies that are set up, one to take payments, one to issue demand letters. It's very convoluted, and you can't figure it out. And so it all starts with the demand letter, and when you get it, there needs to be more transparency. Which patents are you talking about? Which app of mine is infringing? And better yet, what claim on that patent and what feature of my product is the problem? Because they're not going to do that kind of research. They're just going to send you a form letter and then make you do all discovery and spend hundreds of thousands of dollars trying to prove that, you're not infringing. So it's extortion. It's clear and simple. And it starts with the demand letter. And if we knew how many letters were being sent out, if they had to be registered somewhere, then yeah, maybe we could group together and fight this. So that's where it starts. Number one for me is that demand letter. We need more specificity. We need to know which patents specifically, which claims specifically, and which of my products I'm violating. I was fortunate enough to have a few details in my demand letter. They took a screenshot of my app and said, you're infringing. And that told me they spent $2 on my app, and I appreciate that. So at least I got some money from the troll. They also put in, they showed a screenshot of a hyperlink, and they said, this is where you're violating. It's a hyperlink to what was the App Store. I was cross-promoting some other product of mine. And I can't think of a more basic technology used today than a hyperlink in your browser. And that's all it was. That's all it was. So that was the infringement. And then they went on to say, yeah, you're infringing because you're doing distribution through the App Store. And they had all these screenshots of Apple's App Store. We've all used it, right? We've downloaded, whether it's Google Play or Apple, we download apps. Well, that's not my technology. I'm just using their technology. So how could I be infringing? And I asked everybody, I'm like, am I infringing? I had a lot of friends that were lawyers and studied IP and knew all that. And they're like, oh, you're not infringing. You'll be fine. You'll win if you take them to court, and then you do more research, and you're like, well, I don't have the millions it takes to fight this. So number one, demand letter transparency. Number two is the patent quality issue that we have. I don't know why at some point software patents were a good idea, but I can tell you they're not a good idea, and they're killing the economy, and guys like me that want to write apps and build things. Software patents are probably the worst thing this country has ever seen. So we can talk about patent quality, and we can talk about, let's improve that. Every software patent I've ever read starts off with saying, device A talks to device B, some data gets passed, then some data comes back down. And that's the claim. That's always claim number one, right? And that's exactly what the patent that I was being sued over. It was an old fax machine patent that would talk to a server and some data would come back, and that was it. And it's like, well, you just described how the internet works. Maybe we should stop issuing patents that describe basic functionality of the internet. I don't know. I think that's a good idea. So we can talk about quality, but you look at business method patents, you look at software patents, I would say all of them are pretty low quality. And let's start there. Let's get some guidance, maybe from the Supreme Court. I think that would be great. What makes a good software patent, if at all? The last thing, I would say fee shifting. I think that's important. Again, it costs $450 to file a lawsuit, and then, then it becomes the other person's problem to spend hundreds of thousands of dollars to say, no, I'm not infringing, and they did no research. They're just sending form letters. So if we could just make that a little more expensive. In my case, they actually sued me last year. They sued my company. And I was very fortunate to get a pro bono lawyer to represent me. It's probably the first time in the history ever, So I had a free lawyer to fight these jerks. And when they learned that, they were like, oh, well, look, just give us $4,000, we'll dismiss it. And they wanted me to transfer that money into an international bank account through a foreign corporation. My lawyer asked why. Oh, it's because we are not going to pay U.S. taxes on that money. So the company that sued me is not the company I'm paying off. So I really wanted to take this to the end and fight these jerks and get my lawyer's fees, right? Because my lawyer spent $180,000 in time and research just crafting a response to these guys. And I wanted to fight them, and I wanted to get that money. But then you learn, well, there is no money. You can't get any money out of them. There's no money. The company that's suing me has no money because I'm paying some other company. So they've thought of every angle. These guys are not idiots. They're really smart, and they're making a ton of money. So let's make it a little more expensive for this business model, which is not benefiting this country at all. They're not even paying taxes. Let's fix that.
Thanks, Todd. How do you really feel about software patents, though? I think there's some ambiguity left there. I just want to get a little bit more feel from the panelists, and then we'll turn to some questions. I think I had Gail, you online for this, but then we'll turn around for everybody.
So I keep coming back to our keynote speaker. Some of the provisions in Senator Cornyn's bill that we've seen in other, and it's not unique that to him. You see parallel provisions in the House bill as well, do a lot to bring costs down, right? So if nuisance litigation is the problem and high costs drive nuisance patent litigation, bringing patent litigation costs down is a part of the solution to the problem. So take, for example, the provision that requires genuine notice pleading. Right. Today, under current patent law, you can be sued by a patent holder who does not necessarily have to tell you which of your products infringe or how. That puts you in a very difficult position when you're trying to defend against the case. If you're a small companies have budget pressures, but perhaps only have one product. At least they can guess which product is meant. Large companies, we have, untold amounts of products and services and offers. Which one of them infringes? The complaint need not necessarily say. That just drives up the costs of defense because we can't fight efficiently. We can't figure out what we're accused of doing and fight on that. Some other important provisions would lower the costs of discovery. One of the funny things about patent properties, patents as property, is that at least in the high-tech space where we live, patents have fuzzy boundaries. It's not like real estate. When you buy a house, you get from your real estate agent a plat, or your lawyer, a plat that shows you the boundaries of your property. Trespass is easy to determine. When you get a patent from the patent office, at least again in the high-tech space, the boundaries are kind of fuzzy. One initial, it's not clear, for example, whether a certain act is a trespass on the patent until the judge tells you in something called a Markman proceeding. It happens in district court all the time. He tells you in a Markman proceeding whether the boundaries of the patent look like this or the boundaries of the patent look like this. It's a really important point to know from the judge, right? Are you dealing with a big plot of land or a small one? Because trespass depends on that. One of the provisions in the bill, in Senator Cornyn's bill, says all that expensive discovery, and discovery is one of the most expensive parts of any case. All that expensive discovery, almost all of it, should happen after we've heard from the judge what the size of the property right is. Because if we do the expensive discovery early, in all of these areas that the judge later tells us are irrelevant because the patent only covers this much, We've all wasted time, we've all wasted money, and that's on both sides. That's plaintiff and defendant having wasted money. Another important provision is discovery cost sharing. Under that provision, core discovery would happen in the ordinary course, paid for in the ordinary way. Non-core discovery would be available, let's say in this case to the patent holder, but the patent holder would just have to pay for it. If it's non-core discovery, you can still get it, assuming it meets the usual requirements of relevance, but because it's deemed non-core discovery and because it can be very expensive, the plaintiff just pays for it. And again, that's vice versa. That happens on both sides. So we would pay for non-core, the defendant would pay for non-core discovery too. So those are three elements that would bring the cost of patent litigation down, make patent litigation more efficient, and make it less attractive to bring a merely nuisance patent lawsuit.
Yes, Julie, please.
I just wanted to bring up a couple practical concerns that I have, especially about the heightened pleading, whether it's in the complaint or in the demand letters. While I completely agree that we need to make sure that the patent at issue is identified, the product that's potentially infringing is also identified. I think the pending legislation goes too far. Various bills require you have to identify the claims, you have to identify the elements within the claims, and then the elements within the product to identify what's infringing. And from a practical aspect on that, that can at times be challenging. Sometimes that's very easy to do. You can obtain the product, you can pull the product apart, you can look at it, and you can figure that out. A lot of times you can't. I have a client right now, a small startup software company who has 4 software patents, and they have a competitor who, based on public information, appears to be infringing their patents. From what we can tell and what we can gather, it looks like they are, but we can't tell for sure. We don't have a product in hand to look at to be able to go element by element, claim by claim. And so we're trying to decide, do we send a cease and desist letter? We want to open up the communication with that competitor, but because it's just not readily available, short of corporate espionage. We don't know how we get that information, and that's not a unique problem. And that's why you have the discovery process. That's why you open those lines of communication. So while I agree there needs to be more disclosure, I think that we need to make sure that the provisions here don't go too far. On the same note, in patent cases, when you send a cease and desist letter, you don't want to be too clear in what you're doing because you open yourself up to declaratory judgment action. So as potentially a plaintiff, the benefit of being a plaintiff is you get to pick the court, the jurisdiction, the claims that you make. If you make it clear that you're going to sue for infringement, these are the claims, it's infringing, you're potentially opening yourself up to declaratory judgment so that the potentially infringing defendant then becomes the plaintiff, then gets to pick the forum, gets to pick the court. And so while I agree this is a definite problem, I think we need to make sure that, that we rein it in a little bit, don't go too far so that, that we can avoid some of these practical issues.
I was going to say that.
Turnabout is fair play.
Yeah, so I just want to pick up on something Gail said, if I could, Michael. Patents do have fuzzy borders. Basically, patents are an argument waiting to happen. That's just the way that they are, and you do need a federal judge to tell you with certainty what the patent actually is. So you basically have an argument waiting to happen, and because the argument has to happen in court, you have an argument that very few can afford. There's a reason they refer to litigation as the sport of kings. So if we're going to continue to operate on a legal standard of infringement, all we're going to do is argue over how to split the pie as it exists today. If we're going to figure out how to create a commercial standard for deal-making, licensing that's scalable, then we can start to talk about how to diffuse patented innovation into the economy and grow the pie.
I just have to disagree with all that. Vague demand letters are not good things, and vague patents aren't good things. And if the government is going to issue a monopoly, which is what a patent is, then it should be pretty specific. And I just don't see how you can argue that point.
I'm not saying that we shouldn't have clear patents. I'm saying the patents that exist today do have fuzzy boundaries. And when you have something that has fuzzy boundaries, they're prone to argument. And the only place to have that argument is in the federal court, which is ridiculously expensive for both parties. So if we're going to have a property class called patents that are going to have fuzzy boundaries, and we should try to improve the clarity of patents. That would be great. We need to figure out how to do business outside the court, because the court system is a crazy place to serve as a commercial market of last resort.
So I would challenge the premise a bit that the only place to resolve the dispute over claim construction or boundaries or infringement is the courts. I mean, so the AIA, which was passed in 2011, a significant part of that legislation was to create an alternative or more robust alternative to litigation in terms of challenging the validity of a patent. And so now we have this three-track system within the AIA, one of which deals with business method patents, that is meant to create a more efficient mechanism for challengers, and it doesn't necessarily have to be a defendant, it could be anybody, to challenge the validity of a patent that they perceive as being overly broad and potentially invalid. I think that option gets lost in this latest debate over patent quality, patent infringement, and I feel like there's almost like a historical amnesia that we just sort of forget that the AIA even happened. I'm not suggesting that it solved every single problem, but it was a 7-year process to really think in a very judicious way, how do we create another option for implementers who may be facing what they perceive as being an overly broad or even invalid patent. By the same token, a tremendous amount of focus on patent quality, getting it right at the front end. PTO has invested a lot of time and resources focusing specifically on software patents, business method patents. I would also say when we use the term software patent loosely, we forget that it potentially sweeps in a broad range of patented inventions. On the one hand, you have the business method patents that tend to be the subject of like the CLS Alice case that's before the Supreme Court, other federal circuit decisions that are really focused on subject matter eligibility for software-related patents. But at the other end of the spectrum are technological inventions that today are implemented through software as a design choice, whereas 10 years ago they may have been implemented through hardware. So I think it's really important that we get our, we're talking a lot about precise claims drafting. Well, let's be precise in our terminology, because when we make these sweeping statements, all software patents are bad, you potentially sweep in a broad range of highly innovative, highly technological, R&D intensive developments that are incredibly valuable. So I just think it's important that we be reasoned, precise, and empirically driven in our terms and discussion of these issues.
And on that point, just as a sort of PSA, Lori alluded to the Alice case that's before the Supreme Court right now. The court actually heard oral argument on that earlier this week, and at some point before the end of June, the court very well could weigh in with a lot more clarity on what it means to have an acceptable software patent. What exactly about software is patentable, and what do you have to go through in order to obtain that? So the courts could potentially be playing an important role in helping clarify some of these issues too. Lawrence.
I'd like to address, the gentleman over there made a comment a long time ago, and I feel that we still haven't really addressed it, which is that, are we really shutting out the small inventor from, I say we, not in Congress, but, are they shutting out the small inventor? And I want to say that, so I am a small inventor. I hold several patents. One of them is a software patent, and it is crucial to the running of my business. Now, actually, I would not really disagree with Todd when he says that software patents are a little iffy. If it was decided to do away with software patents entirely, I would probably not object for all the reasons he said. That being the case, that not being the case, we have software patents and or in the world, and so therefore I want to protect the things that we have done that are unique and make sure that if nothing else, I'm not prevented from doing what we do because someone else files a patent. That being said, one of my key concerns, and the reason I actually began talking with, I made a remark to Senator Cornyn, and he put me in touch with Noah, and the reason this whole dialogue started was I need to be able, as a small company, to be able to pursue a patent litigation against a larger company that is infringing my patent. That needs to be a possibility. It can't be something that is, it's just now beyond my reach, because if I sue Microsoft, they're going to hire, they're going to spend $3.5 million on my defense, on their defense. They're going to win because I've got my one guy who's working pro bono, who's working for whatever. And then I'm going to have to pay them their lawyers' fees, and I will be bankrupt. And so therefore I can't prosecute. That can't be the case. And so, when we talk about things like fee shifting, And I want to say, so we don't know what the Senate bill looks like because it hasn't come out yet. But the House bill that passed, I'm actually okay with the fee shifting as it is written, because basically what it says is that if I have a reasonable, I wrote it down, an objectively reasonable and substantially justified case, meaning, okay, this wasn't frivolous. You had an argument that you were being infringed. You lost, but you had a good argument. Then the fees don't shift. Now, it's always scary because they can, but I have to believe that if I file a patent lawsuit and I have a good claim, that the fees won't shift. And so I can tally up, figure the cost of what this is going to cost me to pursue and go do that. And so I do sympathize. I am a small inventor. I do face the potential need to prosecute or to litigate a patent of mine, and I need to be able to do that. And so I would personally be against any legislation that made that very difficult. It does make it a little riskier. You are right. I do face the threat of a fee shift if the court finds that I was being unreasonable. But when I look at this, patent troll letter, which, again, it's a $400 million at issue thing. You send out 17,000 letters. You don't have to get a really big return to make money from that. Something has to be done, and if that's the compromise we have to strike, that I have to make sure that my lawsuit is not going to be seen as unjustified before I bring it, then I'm okay with that, as long as we don't go too far. You're right; it cannot keep the small inventor from pursuing a claim against a large one. You are right. Yes, you are right.
What happens if, let's say you have a legitimate claim, and a big company that you're suing decides, yeah, we are infringing, but you know what, he's small, we can afford it, so we'll bring a frivolous defense, and then we'll try to just negotiate a cheap licensing because we know you can't afford to litigate. So there's nothing in there that punishes a defendant from bringing frivolous defenses to force you to sell.
I think that's a great point, and I'm not disagreeing. I do agree with your question about the language, or your comment about the language. The language is that fees will be shifted unless the suit is found to be substantially, objectively reasonable and substantially justified. I'm a little uncomfortable with that. I've discussed with Noah. I don't know how to phrase that better. I wish it. Well, he does. That is his discretion. But the judge can then say, no, I think it was substantially justified, so therefore I won't do it.
Which is the default.
Right, exactly. And just to maybe as a point of information for everyone's benefit, under current law, the standard default is not to award fees. In the American system of sort of the day in court, we don't have a default rule of shifting fees from the losing party to the winning party. That's a feature, some might say a bug, but generally I think Americans consider that a feature of the American legal system, including in patent cases. Where you can get fees awarded is if you can describe the case or persuade the judge that it's in so-called exceptional case, where there was something very serious that happened, whether it was serious litigation misconduct or the case was frivolous, was objectively unreasonable to bring it. But as the gentleman noted, the burden lies on the party that won the suit in order to get the fees. Under the provisions that are being considered now, and they're pretty similar across all the different bills, in the Goodlatte bill that passed the House, in Senator Cornyn's proposed legislation, and some other, I think Senator Leahy's legislation as well, that's all being considered. The shifting would happen, the default would switch, such that fees would automatically be awarded unless the defendant could show, as Lauren said, that his or her litigation was objectively reasonable and substantially justified. So let me, well, you had a question before, sir, so let me come to you.
Sure, absolutely. Thanks, Mike. So it's a comment and a question. I wanted to comment on what Mr. Moore said. So first of all, I appreciate hearing the perspective of an entrepreneur. I think that in general, patent law is an area where not enough is done for small businesses and other actors in that industry. But I also think that what I heard from you, Mr. Moore's perspective, you're off in the technology industry. But I don't think it's the right way to approach the issue. You said something akin to software patents are the worst thing that happened to this country. Of course they're not. There are many bigger problems in this country.
In this room.
But this is the problem I
to my field. I'm sorry, I should have said that. In the computer field.
But, I think that this is an area where there's a lot of, this is not, this area, the here are not simple issues that require a nuanced approach to policy, and I've never seen the iPro help with making good policy. This is an area where good nuanced policy.
Yeah.
So I'm really passionate about this, and sometimes I do probably push the bounds too far, and I think they should be pushed too far. And there's definitely two sides to this issue. Clearly, I'm not on the stance we should eliminate all patents. I think the patent system was originally instituted. I think it was very beneficial. My chief concern is that we used to have a system where you would design and build something, and you'd spend years or money doing research, and you would create something, and you used to have to submit a model to the patent office and say, here it is, this is my design. And for me, I think having something tangible in the physical world, that makes a lot more sense. And, I love the story of the Dyson vacuum cleaner, how he sat there and he made something truly remarkable that was never seen before. And it's in those instances, I think the patent system works well, and it served him very well, because then once he got that patent, he could go and talk to the big guys and try to sell his idea. My issue is with software patents, and if you ever read them, and I've read a bunch, and I'm a software developer, so I think I'm qualified to read these over and see what they say and try to understand them. And they're just so vague, and they're just abstract, and they're just general concepts, and they could be applied to anything. And when I read that a patent has been issued because on emailing your elected representative, I think there's a real problem with that, because I've violated that patent many times this year.
So I just want to interject, because I agree with your comment completely. I think there's way too much heat, way too much hyperbole, not enough light that's being brought to this issue, and it's too important of an issue to get it wrong. So I appreciate your point. During the AIA, the anecdote that was thrown around was the cat pointer patent or the peanut butter and jelly patent. It was, of course there are ridiculous patents that are issued, or they appear to be ridiculous, and that's why we have this process of allowing issued patents to be challenged again at the PTO, and obviously they can be challenged in court as well. But again, this notion that somehow castigating all software patents as being bad quality, overly vague, it's a false statement, because we know that design choices for core technologies, and our technology are the core technology that allows this device to function as a computer and as an access to the internet. Those core technologies are being implemented through software today. We do not want to create a chilling effect on making efficient design choices that allow the technology to evolve. So when we talk about kind of casting a cloud over entire fields of technology, that is the risk that we run. But I just, building on this point of differentiating between what the real problem is and this sort of hyperbolic, hysterical, notion of what the problem is, I think a lot of the provisions that have been talked about in this latest iteration of patent reform, and conceptually, they make good sense. More robust pleading standards, more robust transparency, maybe moving away from the exceptional cases standard of fee shifting. Conceptually, you can see the benefit of those types of approaches in terms of shifting the cost-benefit analysis that these hedge fund-backed shell companies engage in when they decide whether to target 17,000 businesses or one particular startup. But I agree with Julie's point about the heightened pleading, and I think it's a point that really does apply across the board to so many of the provisions that are being tabled. They're overly broad. They sweep too broad of a net, not only targeting, not only prescribing additional requirements that would add transparency to a pleading or create more skin in the game for some of these hedge funds that are now backing patent assertion activity, but they go so much further than that in terms of creating requirements that are excessively burdensome and creating one-size-fits-all approaches to civil litigation that micromanage the historical role of judges, making it so risky for a patent owner, even a legitimate patent owner, to even contemplate a patent suit. So, again, there's merit in the proposals that are being tabled, but we absolutely need to get it right. And I worry that the hyperbole is kind of creating this sense of, oh, we got to do it tomorrow. You know, we got to get to markup tomorrow. And if we rush to judgment, if we rush this legislation through the process without taking the time to get it right, there will be collateral damage. And that collateral damage will be the small patent owners, the small inventors in this country that historically have driven job growth, have created our competitive edge, and have made this system the most successful innovation economy in the world. So there's a lot at stake.
And I share Lori's concern for that. My partner is Jay Walker. He is, I think, the 11th most patented living inventor in the world. And he's named on more than 500 patents, and he's built companies based on his patents, Priceline being the most well-known of those. Priceline is probably what some of the folks in this room would consider to be a software patent or a business method patent. It's gone on to become, a $60+ billion company, a member of the Fortune 500. It's created thousands, if not tens of thousands of jobs. It's served tens of millions of customers. And he's created other businesses off of his portfolio too. And we need fair access to the legal system to assert our rights as patent owners if we have merits. And when you hear about loser pay being the default, that scares the heck out of us because it simply dramatically increases the risk profile of filing a suit. And to us, it's akin to if you're trying to solve a shoplifting problem, lock the front door of the store and don't let anybody in. So you might solve the problem, but you might very well create a bigger one. So when it comes to fee shifting, if that were to be the default mode, we would be very concerned.
And thanks, John. I want to, in our last few minutes, I want to turn to some of the other specific provisions in the bill to try to, I don't think we're going to resolve the software patent conundrum in this room today, and we may never resolve it. But given that there are some specific proposals on the table, and I wanted to just get the panel's sense on two of them. One is the so-called real party and interest provision, which would increase the transparency and avoid some of these shell companies. I'm curious to hear the panel's thoughts on the specific provisions either in the Cornyn bill or in some of the other bills. The other is the customer suit stay or customer suit exception, which would allow customers, the end users, the consumers, to band together and essentially extricate themselves from a lawsuit that should properly be brought against the manufacturer of the device, even though the customers are the ones using. So, Gail or Lawrence, why don't you guys take it away?
I for both of those. So I hold patents, and it seems to me that if I'm going to assert that someone is violating my patent, it's not fair for me to hide behind someone else. I should be able to say, you're violating my patent. And it may be difficult for me because, if they know who I am, then they'll know how to structure their defense. Well, isn't there a standard of confronting your accuser? I don't see how it is all right that I don't have to disclose myself. It certainly has affected me in the case we were talking about with the patent troll. So I'm fine if I have to do that to pursue my patent. The other thing in terms of consumers banding together, again, the troll suit that I was a victim of was legitimately against Hewlett-Packard. But they didn't go after Hewlett-Packard. They went after 17,000 purchasers of Hewlett-Packard machines and said, no, they didn't infringe by building it. You infringed by pressing the button. That's absurd. So I think that makes sense. What happens is that if they band together, basically the manufacturer steps in, all of the the customer lawsuits are kind of held in abeyance while that's going on. I think that, I'm not a lawyer, but to me, that as a sort of your average guy, that seems to make sense.
Gail, did you want to comment on any of those?
I'm good.
You'll stand with Lawrence. Others? Julie, how about your thoughts on some of those specific other provisions like the real party or the customer stay?
Those I don't really have issues with. My bigger issues came from the heightened pleading standard, which we already talked about. I have some concerns about instituting the covered business method post-grant review process, which has come up. It was taken out of the House bill, but I think that it's still being considered. I think the AIA set up that it was going to sunset after 8 years. We haven't gotten to that time period yet. I still think we're looking at the benefits, the pros, the cons of the process, and so I don't think that we should put into law that it is just going to be the law of the land, that it's going to exist. So I think we should wait, we should let it run its course, we should see how it's being used. It was designed to try to go after patent trolls, but I think some of the statistics that are coming out is that it's big companies going after smaller companies, and so it's not necessarily having the intended effect. And so I think that rather than rushing to put that into a bill and make that, and of course expand it to cover software patents, I'm less concerned about that aspect of it, but I think we should wait on that rather than putting that into the legislation. And then I do have some concerns about fee shifting, and I think that the current standard is too stringent. I think that the statistic is that only 1% of patent cases actually have fee shifting currently with the standard that we have today, and I think that that's too few. I think we need to, and the Supreme Court is looking at this. They have one or two pending, I think there's two pending cases at the Supreme Court right now looking at the standard for fee shifting and lowering that standard, and I agree, I think it should be lowered, but I have some of the same concerns as some of the other people on the panel, that if we make it the default that there is fee shifting, that's going to, as people have already mentioned, it's going to discourage people from filing lawsuits, from asserting their patents that they rightfully have the ability to assert. I think it's going to scare off small inventors, small startup companies from asserting their patents, and I don't think that we want that. So while I do think we need to increase how often a judge does shift the fees, I think that having a fee-shifting provision that takes us to the British rule is probably overreaching in this case. So those are my big...
I'd like to comment on that, please. If you're going to get sued by someone, I think it's worthwhile that you could possibly get your legal fees covered. Again, these shell companies have no assets, and that's a serious problem. To get back to the original question about customer stay, I'm a software developer. I integrate multiple APIs and SDKs, and these are things that, you know, Apple and Google and Amazon, they all put out, and phone manufacturers, they put out, and I'm just an end user of this stuff. And I don't think it's fair that I'm going to be sued along with them, and that's what this whole customer stay is. Let the manufacturer sort that out first. Why should the small guys that are just using that technology? All I did was use Apple's App Store technology to process payments. Why am I being sued over that? So I think that provision, those provisions are great in those terms. And as far as fee shifting, I don't care what you want to call it, bonding or whatever. There just has to be a way to recoup your costs if this lawsuit is frivolous.
So just to comment on first of all, I agree with Julie's comments on concerns about expansion of the covered business method patent program, and I also agree with your position on kind of getting the balance right on fee shifting. On customer stay, I do think, for us at least, it's a significant source of concern, not because we disagree with the concerns that the little guy end user who's just using an off-the-shelf product or the equivalent in the off-the-shelf app, should be the first target of litigation. But I think this is another example of legislation that was that purports to solve a specific problem, namely the small mom and pops, the small app developers, et cetera, who are being sued, but in fact is drafted in such a broad way that it could sweep in a broad range of other actors. And so, if you think about how products are developed today, how supply chains function, you don't have these kind of neat divides between manufacturers and customers. And the way that customer definition is defined in the current legislation, it's so broad that it could include a device maker. It could include highly sophisticated corporate entities that aggregate large numbers of technologies into a product and somehow treat them as having the same sympathies as the small business, small end user. And so, again, it's an area where we think there's a version of that language, a narrower version, that could actually solve the defined problem, but right now it's overly broad.
We've got, if you guys want to stick around, we got time, but we'll take a couple more and then we got to get out of the room. Yeah, please, go ahead, sir. Well, I'll let the panel answer also, but I think as Lori alluded to, you know, the AIA does take care of some of those patent quality problems by increasing funding, but also through the inter-partes review process, which provides a really cheaper anyway, and fast way of weeding out the so-called bad patents that are around. It's not going to really help for the old ones that are still out there, but those old ones will expire at some point. So that's the good news, I suppose.
The post-grant review process.
Right.
And that's the point of the post-grant review
Right,
process.
and the existing program for covered business method patents, again, the definition of covered business method patent is already defined in a fairly broad way, and the PTO has made clear that it will, you know, give that definition the broadest possible scope. So I think it's important for companies that are concerned about these issues of, you know, old, bad quality business method patents or the like, you know, to look at the tools that are now available. I think it's only been, I think, 18 months since the CBM program went into effect. You know, we really don't have the data to say that it's not working. I mean, there's no evidence to suggest that it isn't working. So,
There's no evidence to suggest that it is working.
yeah, well, exactly. There's no evidence,
too
period.
early.
Yeah,
Right.
yeah.
Yeah, I would love to see that expanded into the software field, not just financial services. In regards to the last 20 years, what do we do about all these low-quality patents? That's a serious problem. And for me, I'm like, well, maybe starting this year, we can start issuing better, higher-quality patents, and then in 20 years, the situation will work itself out. And so, you know, the next batch of entrepreneurs won't have to deal with the crap that people like me have to deal with.
And the president put out an executive order that the PTO has recognized and is responding to, putting efforts into place to try to curb the overly broad patents, which includes, you know, better training the examiners, hiring more examiners, making patent applicants put in glossaries within their patents. They're coming up with ways that they're going to crowdsourcing prior art. They have lots of different things that they're going to try to do to try to make sure that the quality of the patents that are coming out are going to be stronger. There is a concern, though, that when you're drafting a patent application, and this is from my perspective, but also from my client's perspective, there's an incentive to be vague. And you want to be vague in the sense that when you're filing your patent, you want your claims to be interpreted narrowly when the patent is being reviewed against prior art during the prosecution process. But then once you have your patent, you want your claims to be interpreted broadly so that you can cover your competitors. And so for language to be interpreted narrowly and then broadly, and this is not just in software, this is in all patents, there has to be an element of vagueness in what you're doing. And so that is underlying all of this. And so that's something that we have to think about and address from the kind of the strategic approach to drafting patent applications. So I think it's more than just giving the PTO more resources. I think that's going to help, but there's an underlying issue with how we draft patents and kind of our strategy that really no one's talking about.
Thank you. I'm told that we do have to wrap up. I'm sorry, but if anyone wants to ask questions, I'm sure at least some of the panelists will stick around afterwards. So I want to extend a big thank you to the panelists for bringing their very wide-ranging and very eloquent perspectives to the debate today. So thank you.